Hello everyone, welcome back to the video updates. It's Sade again. Today I wanted to do a quick video for you. I know it's the holiday weekend for the people that celebrate Easter. Happy Easter, and I celebrate Easter as well. So I'm going to do a quick video to address a question that we got earlier this week. And the question is, if there's a trust shown in the chain of title in the property records that owns a particular property, how do you handle that whenever you come across that, if you're in the business of collecting excess proceeds or helping claimants with those excess proceeds? The question is asking about how to handle the situation where there's a trust shown in the chain of title, meaning that a trust is shown in the property records somewhere, either maybe with the tax office records or inside the actual official public records of that county. You find that the party named is a trust. You might be a person that's an heir to the deceased owners and you're now trying to sell the property, or you're somebody that's wanting to collect excess proceeds after a forced sale of that property, either by the tax office or by the mortgage lender. Or maybe you're an asset locator that's working with claimants and helping them to claim excess proceeds. And so when you come across something like that, what do you do next? So let me go ahead and do a quick review of how trusts work in general. So there are usually two different types of trusts. There are revocable trusts and irrevocable trusts, right? So it doesn't really matter within the context of this video whether it's revocable or irrevocable. So for purposes of this video, I'll just go and do a quick overview, and you could do more research into trusts, but those two different types are there. And the revocable or irrevocable trust, it just means that while the person that created the trust is alive, if it's revocable, that person can continue to make changes inside the trust document, which we call a trust agreement sometimes. Sometimes they call it a trust document. The trust document is never public. So it's held closely by the trustee and the principal, the party that puts it together, or the grantor. So the person that put the trust together is the one, usually that's the trustee, and then they select a successor trustee to help manage the trust if that person should pass away, or if something happens to that person, or whatever the case may be. So you usually have the party that created the trust being also the trustee. And so sometimes they don't share the trust document with their children, or they don't share the trust documents with all the children, and somehow the trust documents will get lost at some point because the person passes away and the descendants don't have any idea what was inside the trust document. And sometimes you cannot figure out which law firm did the paperwork in the first place. So if you know what law firm did the paperwork, then the best thing is to contact that law firm, even if it was 10 years ago, 20 years ago, and see if they have a copy of the trust document, because that will be the quickest way to get it. Now, how can you figure out what law firm did it? Well, maybe the descendants remember that there was a specific lawyer or law firm that was helping their parents with the estate. So you could check with those law firms, of course. The other thing, especially within the context of this video and the question, is that there was a trust already shown in the property record. So that means that the person that put together the trust went ahead and transferred real estate into the trust. So inside the deed document, which is what would transfer the title from the person to the trust, the deeds usually have a law firm's name in the document. So you could look in there, pull up that document, and see if you can find out if there was a lawyer that had information on that document, or if there's a law firm shown on there. So you'll contact them and ask them if they can give you more information, but of course they'll want to see authorization from that particular party. So if you are the heir, they'll probably deal with you after they verify your identity. But if you're an asset locator, you'll have to go through that claimant to do all of that legwork. Okay, so those are the ways that you could get the information. So what if the law firm doesn't know anything about the trust agreement or doesn't have the actual trust agreement? Or what if the law firm was not the one that did the trust agreement, so nobody in the family can find it, nobody has any idea? The only way we know that there's a trust is that there was a deed that transferred property into the trust, right? Remember, if there was no property transferred into the trust, it should not be showing in the chain of title as if the trust owns that property, because that's not an effective trust if it doesn't have any assets. So that's actually not a bad thing. So if they say, well, there was a trust, but you don't see any deed from the individual to the trust, then you don't have to worry about it. So the lawyer would sort that out really quickly. The one that causes difficulty is when there's an actual deed showing that the party that created the trust transferred property to the trust, and now nobody knows what the trust document says was supposed to be done with that property after the person dies. So when it's revocable, you could continue to change it. Of course, when it's irrevocable, that means that it can only be changed usually with a court order. However, inside every trust document, it shows what's supposed to happen when somebody passes away, when the person that created the trust passes away. What's supposed to happen? Usually the trust will be dissolved. That's the norm. And then the assets of the trust will be transferred to the beneficiaries. It'll be distributed just according to the person's instructions before that person passed away, right? However, if you cannot find the document, you don't know what those instructions are. And some of the time, the instructions actually do state that the trust continues for generations and generations after that person has passed away. So how then do you sort it out if you are trying to collect excess proceeds, or you're trying to sell the property, but there is no way to know who actually owns it, who was the beneficiary that owned that property? Because remember, if it's in the case of the excess proceeds, the beneficiary who was supposed to get the actual property would also be the one entitled to the excess proceeds. So all those questions are kind of complicated. However, there might be some shortcuts around it. Some of the time people end up in court because nobody remembers what was inside the trust document. If people claim that they remember the contents of it, then they could swear to the truth of what they're saying. They could put an affidavit together regarding the contents of the trust agreement, and then you could use that to satisfy the title company sometimes, or you could use that to satisfy the lawyers, or you could use that to satisfy the lender's attorneys if you're trying to collect the excess proceeds, or the tax office's attorneys, or the county's attorneys when you're trying to collect those excess proceeds. So that affidavit could actually work. Usually it's not an issue if everybody's on the same page. So let's say that that person passed away and only had 3 children, and all the 3 children signed the affidavit saying, yes, we were all supposed to be beneficiaries of the trust. You know, the assets of the trust were supposed to go to all 3 of us equally. If they all swear to that, then nobody is going to question them, right? So they can still go ahead and sell the property if that's what they intend. The only time where it ends up going to court and gets all dragged out is if different people have different recollections of what the trust agreement says. Some people might say, well, you know, Dad wanted me to be the only one to have that particular property. I remember that. And the other people will say, no, that's not what I remember. So that's when you start running into issues where then they have to go to the court and sort it out. And that's going to be a little bit more expensive. It's going to take more time. Now, the other thing that some people can do, of course, is try to find the document, go into the safety deposit boxes. If, you know, the person just died recently, if you know where they used to bank, you can look into that a little bit more. But even to get into the safe deposit box, you would need some sort of authorization. You need some sort of court document sometimes in different states. So that's why it gets a little bit complicated. The best thing is for the person putting together the trust to make sure that the children know about it, to make sure that the law firm has a copy, and that the law firm knows to alert somebody to the fact that they have the trust document if the person passes away. But how do the lawyers know that the person passes away? You know, sometimes they're not even told that the person has passed away, so they have no idea that they're supposed to step in, unless, of course, a lawyer is named as the trustee or successor trustee inside that trust agreement. So in that case, then the lawyer would contact the heirs or beneficiaries, as the case may be, and then follow the instructions of the trust. So the main things, the three takeaways from this video, I guess, is that if you come across a trust, don't let it scare you. If you see that it says, Smith Family Trust as the owner of that property, don't let it scare you. Go dig a little bit deeper, find the deed document that transferred the property into the trust's name, because the deed document would mention who the trustees were or are. And then you can look and skip trace and find those trustees. If they're still alive, those would be the people that you would contact to try to help them with the excess proceeds if you're in the business of locating assets for people. Now, if you come across one where the trustees are now deceased, you still have their full names inside the deed document, so then you have to go one level down and look for their heirs. And most likely the heirs are going to be the successor trustees, but sometimes they're not. And some of the heirs will have the trust document in their possession. Sometimes family members intentionally destroy the document if it's not benefiting them, so that they can argue and contest the contents. So I hope this video has been helpful to you. And remember that with the trust, they have revocable and irrevocable trust, but actually that doesn't affect the ability of the trust to continue after the owner of the trust would have died. So the instructions inside the trust agreement is what would tell us whether the trust survives the death of the owner or whether the trust is extinguished. However, you could argue that it's extinguished if you cannot find the trust document. And then if it's extinguished, then a lot of the times we're able to argue that if it's extinguished, nobody knows where the document is, nobody knows what it says, then the estate, whatever is left, would pass according to the regular laws, not according to the trust instructions, because we don't know what those instructions are. So we'll then allow the assets, so to say, of the deceased owner to pass according to a will, if there's a will, or to pass according to the default intestate laws. Remember, there's some default laws when somebody doesn't have a will. So usually when they cannot find the trust document, they also cannot find a will. So that's just the way it goes. Life gets a little bit complicated when people pass away. But I just thought I'll do this video to tell you that don't think that it's a dead end. It's not automatically a dead end. You could still help the family members. And if the family member is the one watching this video, just remember that you just consult a real estate attorney in that state, and the real estate attorney will be able to argue in your favor so that you don't have to go through a whole lengthy court case to then get a court order to say that you are the person that inherited the property. You can do a shortcut by that affidavit that I mentioned, or by arguing that the trust was extinguished at the time of death, and so that you are the legal heir and that you will inherit it under the state's default laws. So that's what I wanted to bring you today. I hope this video is helpful to you, and happy Easter for the people that celebrate Easter. And I'll talk to you next week. Remember, if you like the video, click like, please. And if you haven't yet subscribed to the channel, remember to subscribe and hit that bell so that you can continue to get notifications of future videos. Thanks as always, and I'll talk to you next time.